With this lecture, we intend to complete the analysis of the regulation of tariffs under the rules of the WTO. We have to a great extent discussed these matters when we talked about schedules of concessions, and you already know the possible forms of customs duties. You know how those duties could be levied, and you know the concept and the structure of the schedule of concessions, so that you have the general understanding of those maximum levels, and you keep in mind the difference between the bound rates and applied rates, which is very relevant for the WTO rules. And you're mindful of the fact that it is only bound rates that are there in the schedules. We also discussed the questions of the economics of tariffs, and we understood that tariffs are bad and tariffs lead to market inefficiencies. However, the approach that was developed in the GATT times was that tariffs should be reduced and not completely eliminated. So the purpose of this lecture is to understand how exactly the provisions of the GATT address tariffs, what other payments could be levied on the fact of importation and importation of a product apart from the tariffs, if those could be introduced. And thirdly, to understand if there are any exceptions to the general rules with respect to tariffs, and if any other payments on imports could happen within the auspices of the WTO rules and tariffs. So that is the plan for this lecture. The topic maybe is not the sexiest, however, those tariff rules remain the underlying ground for the functioning of tariff protection, border measures generally with respect to price-based border measures. Therefore, understanding those is really essential. So tariffs, as we understood, are not treated as a perfect instrument of regulating the market, but tariffs are not prohibited. And still, tariffs are reduced, and they have been reduced since 1947 under individual concessions, individual tariff concessions. There is no set uniform level of tariffs for all members, and as we talked about that in our lecture on schedules, for one and the same product, like say a chair, one WTO member could apply one tariff, whereas the other WTO member would apply completely different tariff. However, there is the general understanding amongst the WTO members, and it has been also reflected in the recital number 3 to the Marrakesh Agreement, that one of the goals pursued by the World Trade Organization is reciprocal and mutually advantageous arrangements directed to the substantial reduction of tariffs. So we are not yet ready to give up tariffs completely, though you have seen that for many economies, tariffs do not seem to be the major tool of protection from foreign competition, as far as the average levels of tariffs greatly decrease with time. But that is actually the result of the functioning of the GATT and the WTO, because the situation in 1947 and the situation today differs greatly in the average volume of applied tariffs among the WTO members, among the GATT contracting parties. And moreover, within the GATT, in Article 28 bis, there is a special mechanism that provides for further reduction of tariff bindings through the so-called tariff rounds. And as a result of those rounds, schedules should be reviewed, schedules should be further liberalized so that there will be further reduction of tariffs. How does it work? Are there any modalities of those reductions? Let's just see the history and understand how those mutual tariff reduction rounds function. So within the GATT, there were 8 tariff rounds, and I think we mentioned it in our lecture on the history of the GATT. Those 8 tariff rounds between 1947 and 1994 dealt with many questions, but the first 5 rounds, they are highlighted in bold, were entirely concentrated on the reduction of tariffs. And further, the agenda has significantly broadened to include other rules, and we know that there were some of the new agreements even that came into life following, let's say, Tokyo round or the Kennedy round. So the agenda for negotiations greatly broadened. However, the first 5 rounds were the pure, full-fledged tariff rounds, which were aimed at the reduction of tariffs. And you may see the figures here that, according to the estimates, the decrease in tariffs in non-agricultural products is impressive. In 1947, the average tariff on non-agricultural merchandise products was about 40%, whereas in 1995, as for non-agricultural products, the decrease is obvious. The average tariffs were in 1995 3.9% for non-agricultural products. And within the WTO, there is the so-called Doha round that was launched in 2001, also sometimes referred to as Doha Development Agenda. Unfortunately, there was not much of progress reached during the Doha round in sense of tariff reduction, but the round is not over yet. And as for the modalities of reductions, the GATT does not fix any exact model of negotiations, and those models could be decided by the members participating in the round at the beginning of the round, and different approaches have been implemented. Option 1, during the first 5 rounds, it was very much in use. It is the so-called product by product request and offer approach. How does it work? It's mainly bilateral negotiations with further revision to be agreed with the principal suppliers and importers. And therefore, it's a lengthy exercise when each and every product line would be reviewed and renegotiated. In practice, it turned out to be not only lengthy, but also very limited in volume and not really systematic, just because of the huge amount of work that has to be performed for such reduction to be systematic. And unfortunately, tariff peaks often remained unchanged because for the most sensitive questions, GATT contracting parties were not ready to give up their high level of protectionism. And moreover, there were issues with the participation of smaller countries. They participate less, again, because they do not that actively participate in international trade. They are not principal suppliers and importers. Therefore, they trade less, and therefore their involvement in those negotiations was less. Thus, this approach was abandoned. During the Kennedy round, a different approach was proposed and applied. It is the so-called linear reduction across the board. It is an agreement to cut rates that apply to all tariffs, to all products, with very minor exceptions that require specific negotiations. And the advantage of this approach is that it is essentially multilateral, but it is still found unequal. As in practice, it turned out to be unequal. Many members with low tariffs reduce those by the same average as those members that have high tariffs. And this disparity in tariffs between the members does not really permit make this approach effective. So this linear reduction was also not implemented further. And from the Tokyo round, the prevalent approach was the so-called formula approach. The idea is to develop some sort of a formula which will not be linear. It's some form of a non-linear reduction techniques that are aimed at ensuring that higher tariffs are subject to deeper cuts, whereas lower tariffs are subject to lower cuts. And different formulas have been used. The modalities of those formulas have always caused a lot of debate, and it is exactly the modalities of tariff cuts that caused a lot of trouble in negotiations, in particular during the Doha round. So determining how those tariff rounds result in the reduction of tariffs, it's the question of negotiations, and different approaches have been implemented. You could try find on internet more information about those formula approaches. The famous Swiss formula approach, for instance, as an option for mutual tariff reduction. But again, there is quite a lot of that, quite a lot written about different modalities and their different result to ensure equality and ensure the mutual interest in participation in such discussions. So just to recap what we have already discussed, you remember the schedules of concessions, and you remember that those are the obligations with respect to the maximum levels of tariffs that could be applied by WTO members. They can be worded in various forms, either as ad valorem taxes, ad valorem charges, or as specific charges, or as a combination of both. And you also remember that WTO members are always free to apply tariffs below those ceilings, but they can never go above the maximum bound rates, which are inscribed in their schedules. And just to remind you the text of GATT Article II, which we will work a lot with during this lecture. GATT Article 2.2, this is a mistake, it's 2.1 clearly. 2.1 says that each contracting party shall accord to the commerce of the other contracting parties treatment no less favorable than that provided for in the appropriate part of the appropriate schedule annexed to this agreement. And you may also recall the second part, which is specifically relevant for the table from the schedule that we just saw. The products described in part 1 of the schedule shall, on their importation into the territory to which the schedule relates, be exempt from ordinary customs duties in excess of those set forth and provided therein. So again, it's the maximum levels of tariffs. WTO members can apply lower tariffs if they wish. However, with respect to all products in part 1, and those are exactly the goods schedules we are using now, and we are now analyzing, those products shall be exempt from ordinary customs duties in excess of those duties which are inscribed in the schedule. So this is already more or less known to us, more or less clear to us. And now let's think of more difficult matters. As I said, interpretation of schedules could be very difficult. I gave you the example of new products, like an iPad, during our lecture on membership and accession, when it is unclear how to classify a product. However, in practice, classification can be complicated even if we talk about existing products which have been involved in international trade for already a lot of time. And one of the disputes that is particularly tricky and that could give us a lot of useful insight to understand how tariff bindings should work and how they shall be interpreted is the case of the dispute settlement body, which is called EC chicken cuts. And it related to frozen, boneless, salted chicken cuts. Well, the image I found on internet is not really frozen chicken cuts. It looks more like fresh. However, imagine those frozen, and these particular pieces of frozen boneless chicken meat were subject to a big debate with respect to the interpretation of the schedule of the EC. Let's see the options for classification. So you recall the structure of national nomenclatures. This is combined nomenclature of the European community, and the European community's schedule provided for two options to classify those frozen boneless chicken cuts. Well, option one, we can see the code 0210, meat, edible meat, salted. And then it includes various types of meat, including this tariff item number 02109020, other salted meat. And the final bound rate, according to the EC schedule of concessions that was applicable to this other salted meat, was 15.4% ad valorem. It is a relatively high tariff, but given that we are talking of a product of the agricultural sector, meat sector, it is very sensitive, and you know that European farmers receive a lot of state support, and they are fully dependent on state support for their survival. Therefore, clearly it is not that bad. So this is option one, and this was the option that has been actually implemented for a number of years. Option two, to potentially apply to the very same frozen, boneless, salted chicken cuts, was a different tariff item number, which says just poultry meat, cuts, boneless. And you see that the code is different, so even the subheading is different, and clearly the tariff item number is different, and the final bound rate was completely different. So to begin with, it's not an ad valorem duty, but it is a specific duty. And for 100 kilos net weight, the customs duty was determined to be over 100 euro. Moreover, there was a high risk of a special safeguard that could be applied to this product under the Agreement on Agriculture, whereas it could not be applied to this product under the GATT agreement, because this right with respect to that particular product line has not been preserved. But putting that aside, it's more a question of the Agreement on Agriculture, which is not subject to our discussion now. If we would convert it into effective ad valorem rate, it would be something around from 40 to 60% in the times of 1997-2003, according to the estimates of the claimants in this case, in particular Brazilian and Thai meat producers. So they were claiming that the application of this classification would lead to a dramatic result of the significant increase of the tariff protection and significant closing of the European market for chicken cuts coming from abroad. So in 2002, EC reclassified under its own classification system with administrative guidance given to the customs officials that frozen boneless chicken cuts that have been impregnated with salt now need to classified not as salted meat with 15% valorem customs duty, but as the other item number, boneless chicken cuts, with a big increase in the applied customs duty. The two complainants in this matter were Brazil and Thailand, and Brazil and Thailand actually disagreed. And in essence, actually, the whole question was the category under which these salted, frozen, boneless chicken cuts at issue should fall under. The question is whether this reclassification is permissible under the WTO rules. The claimants insisted that products were duly classified as salted, and there was a certain content of salt in it, from 1.2% to 3%. And there is a big section of the panel report analyzing these different salt contents, whether it makes a product different or not. But again, Brazil and Thailand insisted that the classification was applied from 1996 to 2002. It was absolutely correct. There was salt added to these products, and therefore these products should be classified as salted meat. The position of the EC was different. EC was stating that the salting took place not for actually making the product salted under the classification. Maybe it was just an artificial addition of a marginal volume of salt. It was not actually intended to make the product salted. It is frozen boneless chicken cuts and nothing more, whereas it would only be salted products and could be classified as a salted product in case this salting was undertaken for the purposes of long-time preservation of the product. So that was the positions. That was the position of the EC, and actually the three questions the panel had to rule on was under which classification does the product at issue fall? This is question one. Question two is whether EC correctly interprets the word salted in a meaning that the key notion of it is the notion of preservation. And in order to be preserved with salt, here is the quotation, in order to be preserved with salt, meat should be deeply and homogeneously impregnated with a level of salt sufficient to ensure long-term preservation. So if there is some salt added, does it qualify to salted meat, or should there be some deep and homogeneous impregnation? That was the second question. And the third question is whether this EC classification practice that was established from 1996 to 2002 should have any meaning and whether it should have any legal value. So these are the three questions which were at stake in this dispute. So with respect to the interpretation rules, this is a relatively legalistic question, and maybe it's more an exercise for lawyers, but here we need to understand that interpreting any provision, interpreting any text, because there is not much we can actually get from the text itself without the interpretation. So yes, you see that both categories are more or less applicable. Yes, there are two sides of a coin. Both parties have some reasoning that may be plausible, but in order to come to the legal conclusion, we need to somehow interpret these provisions. We need to give them some meaning, and we need to explain what was meant by each of the two categories. And law knows, legal theory knows various approaches towards interpretation. And domestic legal rules on interpretation are different. What is most important? The intent of the parties, the underlying reasons for the formulation of the rule, or should we focus purely on the text and nothing more and go deeply in the details of the textual interpretation? Can we take into account any other rules of international law? Can we see other, say, other schedules, or can we try to establish any long-standing practice of interpretation? So all these results in the raise of legal questions which require some response. So what is the schedule in essence? We discussed that already, and we remember that under the GATT Article 2.7, schedule of concessions is nothing but an integral part of either the GATT itself, or they are made an integral part of the accession protocol, so they also having the nature of an international agreement. So in any case, those lengthy tables with bindings are international treaties. And there are rules on the interpretation of international treaties that have to apply under the rules of public international law. And this is one of the items that this EC Chicken Cuts appellate body has to take into account. With reference to the appellate body position in the case on EC computer equipment, the appellate body emphasizes that a schedule is an integral part of the GATT 1994, and the concessions provided in the schedules are nothing but the terms of an international treaty. Therefore, in order to interpret these provisions, we need to apply the general rules on treaty interpretation. And those general rules on treaty interpretation are set out in the Vienna Convention on the Law of Treaties 1969. It's Articles 32 and 31 and 32. Again, this may be a little legalistic, but we need to understand the methodology of interpretation, and therefore this methodology that is set out in the Vienna Convention on the Law of Treaties becomes of utmost importance, because this is the method you need to apply in order to read those schedules in case of a conflict. The second question, which was here in place, whether the harmonized system actually has any relevance. So we remember that all those schedules are based on the HS, first 6 digits. However, we keep in mind that still schedules are not fully dependent on the HS, because there are additional product line digits, 8 or 10, 8th or 10th digits, depending on the national classification. In the case of the EU, it was a 10-digit classification number. But still, for the interpretation of these schedules, can we use the harmonized system? Do we need to use the harmonized system? What are the approaches? And if we took the methodology of the Vienna Convention on the Law of Treaties, what is the legal ground to use these HS instruments? So the appellate body in paragraph 199 emphasizes the broad consensus that was there between the GATT contracting parties to use the HS as a basis for the schedules. And in view of the appellate body, this consensus was an agreement between WTO members relating to the WTO agreement that was made in connection with the conclusion of the GATT. So if you see the text of the Vienna Convention on the Law of Treaties, those agreements which were made in connection with the conclusion of the other agreement are part of context, and they shall necessarily be taken into account when interpreting the text of the agreement itself. So according to the appellate body, the harmonized system is a part of context under the Vienna Convention on the Law of Treaties, and therefore it is very relevant for the purposes of interpreting tariff commitments in the schedules. So yes, harmonized system is important, and it shall be taken into account when interpreting the specific product lines. So trying to understand the logics of these two different subheadings of salted meat and other chicken meat or other poultry meat, or however it is called there, could shed some light on the meaning of even the category of salted meat, for instance. So the next question was the interpretation of the classification that was applied by the European communities from 1996 to 2002, and whether it can have any normative legal value. So if the country has been classifying a product in a particular manner, could it switch its position? And would this lengthy classification experience matter? And again, as long as we operate under the rules of the Vienna Convention on the Law of Treaties, that is the only legal ground for us to understand the legal rules of interpretation. The appellate body, relying on the Vienna Convention on the Law of Treaties, tries to understand whether this practice, administrative practice, could be considered under the Vienna Convention on the Law of Treaties as a subsequent practice in the application of the treaty, but most importantly, see the text of VCLT Article 31(3)(b. It says, subsequent practice which establishes the agreement of the parties regarding its interpretation. And it was the position of the claimants that actually, with respect to this very peculiar product lines, there was only one country internationally that had this particular wording in its schedule of concessions, in its combined nomenclature in our case, and therefore, as long as all other WTO members accepted this classification, as long as they accepted this approach under this particular tariff line, there is a need to consider this to be a subsequent practice which establishes the agreement of all WTO members. And the panel, in a way, agreed with this approach. The panel relied on this classification as subsequent practice which establishes the agreement. However, the appellate body completely disagreed. The appellate body was reversing the findings of the panel that stated that because other WTO members did not protest against this classification practice, they can be presumed to have accepted it. Is it really so? So if a country follows a certain pattern of classification and others do not protest, would it really amount to an agreement between WTO members? The appellate body says that in specific situations, the lack of reaction in light of the circumstances could be understood as acceptance of the practice by the other parties. And those situations, according to the appellate body, may occur, for instance, when a party that has not been engaged in the practice has become aware, was made aware of it by the other parties, for example, by means of notification, by virtue of participation in a forum where it was discussed, but did not react to it. So there can be situations where this lack of reaction or silence could amount to an agreement. However, in general, and this is important, the lack of protest against a member's classification practice should not be understood on its own as establishing an agreement with that practice by the other members. So we could not give, in the circumstances at hand, we could not give the practice of EC any particular value in the context of interpretation under the Vienna Convention on the Law of Treaties, because though it was subsequent practice, but it did not really establish the agreement of all WTO members on how to interpret the treaty text. So what are the conclusions from the EC chicken cuts? Well, actually, so that you know, EC lost that case in a way that this reclassification was considered illegitimate. And apart from all these factual backgrounds, because they greatly rely on the evidence that was put before the tribunal, and it requires more detailed discussion on what sort of evidence one needs to bring to the panel so that to convince them. But however, what are the general conclusions that we should make? The general conclusions are pretty simple. On the one hand, schedules of concessions are international treaties. They shall be interpreted in accordance with the customary rules of interpretation of public international law. It's the Vienna Convention. The second conclusion is that the harmonized system is really relevant for the interpretation of schedules. It forms context of the schedule. And third, national classifications do not necessarily form subsequent practice under Article 31(3)b unless there is abundant evidence that would show the acceptance of this party by other treaty parties. So this is with respect to the interpretation of the schedules, and you see that even such minor disputes, which may seem extremely technical, but we understand that there are millions of dollars behind these restrictions, and we understand that it results in greatly reduced access to the European market for Brazilian and Thai producers, and that results in all the negative consequences, both in Brazil and Thailand, for the producers of those frozen boneless chicken cuts. So it may have even negative social consequences. It may have influence on unemployment, whatever. So indeed, when we talk of even these technical matters, there is a lot standing behind it, and those conclusions may have vital importance for the functioning and existence even of certain producers and industries in foreign markets. The other question that is also quite tricky. You may recall that the schedules can have different forms of customs duties. In them, it can be specific duties, it can be ad valorem duties. So indeed, there is some form that has been selected at the moment when the schedule was drawn up with respect to each particular product line included in the schedule. The question is whether a member may apply a specific duty in a case it fixed an ad valorem duty. So can they change the format of a customs duty? Can they change the type of a customs duty if they somehow guarantee there is no devaluation, there is no negative impact on the market access commitments that were there in the schedule? So there is a big risk of potentially affecting the value of concessions indeed if we start applying a different type of a duty. It is simple when we have the ad valorem and ad valorem comparison or specific duty. The applied rate can always be either below the maximum bound rate or at the level of the bound rate. However, when we try to change the methodology, could we do that? GATT Article 3.3 specifically says that no contracting party shall alter its method of determining the dutiable value or the method of converting currency so as to impair the value of any of the concessions. And actually, in one of the cases called Argentina Textiles and Apparel, the panel tried to formulate the general rule that governments cannot completely switch from one type of the duty to the other one if the schedule provides for, say, an ad valorem duty. You could not switch to the specific duty or vice versa. Or maybe you could it's particularly difficult if we talk of specific and ad valorem. But again, switching from one to the other can really negatively impact the value of concessions. So that was the position of the panel. The appellate body actually disagreed. The appellate body in the case Argentina Textiles and Apparel says that under certain circumstances, there could potentially be a mechanism that could provide such calculation of a new duty that would not threaten the value of the concession. So if a member manages to design a certain cap of the level of duty, which would ensure that even if the type of the duty changes, but then the actual value of the concession is not threatened, then potentially that could be done. So there is no straightforward prohibition on the change of the type of the duty. However, it is not possible if it results in the ordinary customs duties that would be in excess of those provided for in the member schedule. So members should develop some form of, as appellate body calls it, effective legislative ceiling, so that to ensure that the newly worded concession does not threaten the value of those market access obligations which are there in the schedule. So yes, it is not straightforwardly bluntly prohibited, but again, developing a scheme that would make it function methodologically can be very difficult. Now, this is with respect to ordinary customs duties. So we are clear with the fact we cannot introduce any customs duties in excess of those provided for in the schedule. This is simple and straightforward. Now let's make one step further and keep reading paragraph B of Article 2.1 of the GATT. The second paragraph, the second part of this paragraph reads as follows. Such products shall also be exempt from all customs duties or charges of any kind imposed on or in connection with the importation, in excess of those imposed on the date of this agreement, or those directly or mandatorily required to be imposed thereafter by legislation in force in the importing territory on that date. Now, let's put aside the end of the sentence. Let's try to understand the essence of it in the very beginning. So, ordinary customs duties cannot be higher than the bound rates. Moreover, it's a separate obligation. Products shall be exempt from all other duties or charges of any kind imposed on or in connection with importation. So it's not only that we prohibit customs duties above certain levels. It is also that in Article 2.1b, we prohibit all other duties or charges of any kind that will be imposed in connection with importation. And we see that there is a chance for some duties to be imposed. They cannot be imposed in excess of those which were imposed on the date of this agreement, or those required to be imposed by the legislation in force on the date. However, don't try to focus on this end of the sentence, because with the understanding on the interpretation of Article 2.1b that happened as a part of the Uruguay round, situation got much easier. Let's now again try to get the essence of it. So, ordinary duties, ordinary customs duties or customs tariffs should not exceed those levels that in the schedule. Other duties and charges are not possible at all. So we cannot impose any other duties and charges, however we call them, statistical taxes, foreign exchange fees, security deposits on the importation, whatever. You can call it a tax, a fee, a toll, a payment, even a tribute if you wish. So the name of the payment doesn't matter. The only thing you can charge on import is ordinary customs duty. Any other payments are not permitted. And they're only permitted if, and there are many, many other things to keep in mind, it's the second part of the provision. So now what was the new interpretation provided by the understanding on the interpretation of Article 2.1b during the Uruguay round? It is pretty straightforward and simple. It says, in order to ensure transparency of the legal rights and obligations deriving from paragraph 1 of Article 2, the nature and level of any other duties and charges levied on bound tariff items shall be recorded in this schedule. It is understood that such recording does not change the legal character of other duties and charges. So now we do not need to think about what was there on the date of entering into force. What was the date of entering into force? How do we find out what was there in the legislation and so on? That can all be completely kicked out of the picture, because now any other duties and charges, if members wish to apply them, need to be also inscribed in the schedule. And if you would recall the image of the table of the schedule, you may recall there was a column right next to INR, initial negotiating rights, there was a column ODC. And in the Russian schedule, it was always 0000. So there was not a single occasion, at least we didn't see a single occasion, when any other duties could be introduced, and there are actually no such occasions in the Russian schedule, when other duties, apart from ordinary customs duties, could be imposed. So for some WTO members, certain payments can be permitted, but those permissions would rely on the text of the schedules. So general customs duties, ordinary customs duties are restricted. Other duties and charges are not permitted unless inscribed in the schedule. So this is it. This is more or less clear, and it is important that we now see both elements of Article 2.1b. On the one hand, ordinary duties not exceeding the ceilings. On the other hand, no other payments on imports possible. That is the approach, and that makes a lot of sense, because then you understand that those concessions indeed don't get somehow undervalued because of the possible other fees, payments, whatever is done. All you want to take should be reflected in your schedule. Unless your schedule does not specify for any other duties, then the only thing you could do is actually the bound rate, and that is it. Now, with respect to exceptions. Article 2 of the GATT, as most of the other provisions we'll be dealing with, does have certain exceptions right in the text of it. And I would invite you to have a look at Article 2.2 of the GATT. It would make, again, a lot of sense if you would follow this text on your own and not just read the slides, because again, working with the text yourself makes a big difference. So if we open Article 2.2, we may see the exceptions. And the rest of our lecture today will be devoted to those exceptions. So what are those payments which could be still charged on imports apart from ordinary customs duties, in addition to those things which are inscribed in the schedule? So yes, there are possible additional payments, but they are very limited, and they are here in Article 2.2. Let's see what is written here. Nothing in this article shall prevent any contracting party from imposing at any time on the importation of any product. And then you see A, B, C. So there are three elements. There is some charge equivalent to an internal tax. We will discuss it in more detail. So in addition to the customs duty, we could actually impose a charge equivalent to an internal tax that is in respect of the like domestic product, or in respect of an article from which the imported product has been manufactured or produced in whole or in part. B, it can be an anti-dumping or a countervailing duty that will be also added on top of the customs duty. And third, there can be a charge that will be fees or other charges commensurate with the cost of services rendered. So if I were to put it in simple terms using the words, the terms of art, using the more simple way of putting things, there are three exceptions which are there in Article 2. Exceptions under Article 2A is called border tax adjustment, and we will talk about that in more detail. In B, anti-dumping and countervailing duties, and C, charges for services at the border. So those payments can be levied on the importation of any product in addition to the ordinary customs duty. Irrespective of what is described in the schedule, governments are free to implement these instruments. The appellate body in the Colombia Textiles case emphasized that this list is a closed list, and it sets out all instances in which bound rate tariffs may be exceeded. So this is a closed list of exceptions, A, B, C, nothing more. And we will now go through the three of them. We will actually start with the easier one, charges for services at the border, then switch to the border tax adjustment, and anti-dumping and countervailing duties will be subject to the next lecture, which will be a little separate because it will be on trade remedies in a little broader perspective. So, charges for services at the border. As Article 2.2 calls it, fees and other charges commensurate with the cost of services rendered. So here are two matters which are important in the text, which we need to identify when reading this text. So to begin with, if we talk of fees commensurate with the cost of services rendered, there should be some service rendered at the border. This is the first most important matter. Secondly, we need to keep in mind that the level of charge should be commensurate. And what is commensurate in English? It means that the level of charge must not exceed actually the approximate cost of the service. So this cost should be reflected in the charge. Otherwise, if the charge will be completely disconnected with the cost, it will not be commensurate. So these are the two basic underlying things we already understand just having read the provision. So what are those services that customs officials could provide? There are many services customs officials could provide. Well, clearly, when a product is brought to the border, sometimes it may require some stockpiling. And it may require stockpiling with necessary protection, with security. There should be a roof, for instance, to protect it from rain, or there should be a fridge necessary for some perishable goods, possibly, or maybe not. There can be other services needed for the drivers, for instance, if we talk of crossing the border on a truck. So there can be various services, and those services, for instance, well, we don't have that many disputes with respect to this provision, could include some interest charges and costs in connection with the lodging of security associated with the import certificate. So that was one of the examples when no violation was established, when EEC charged these costs in connection with the lodging of security. And nonetheless, we have situations which clearly demonstrate that the costs for services rendered were not commensurate with the actual charge, and the charge was not commensurate with the cost. Let me give you the other example. The panel in Argentina Textiles and Clothing was talking of the so-called statistical tax. And the statistical tax in that case was an ad valorem charge on imported goods. And it was a clear violation of the provision, because when we talk of an ad valorem charge, then we clearly do not really relate it to the cost of the service rendered. If the charge is calculated based on the value of the product and not on the cost of the service, then Article 2.2c is violated. So as for charges for services at the border, I don't think it causes much concern and trouble, and I guess you understand the concept. Those can be charged in addition to the ordinary customs duties. Now, the next exception to Article 2 is border tax adjustment. And it is a more complex thing, which will require some more time for us to go through it. Let's now read the provision and try to understand it. So nothing in this article shall prevent the contracting party from imposing a charge equivalent to an internal tax imposed consistently with the provisions of paragraph 2 of Article 3 in respect of the like domestic product or in respect of an article from which the imported product has been manufactured or produced in whole or in part. It is a relatively lengthy provision. Let's now delete the part of it that talks of paragraph 2 of Article 3. Just to make it simple at this stage, we will talk about this provision in more detail later, but so that you understand it now, it says that such an internal tax should be not discriminatory when we compare imported product and domestic product. So this is a non-discriminatory tax. Let's now omit it for a while, because once we go through Article 3.2, you would not have any troubles with interpreting it. So a charge equivalent to an internal tax in respect of the like domestic product or in respect of an article from which the imported product has been manufactured or produced in whole or in part. So breaking it even further down, we can introduce a charge. This charge should be equivalent to a non-discriminatory internal tax, and this internal tax should apply in respect of the like domestic product or in respect of an article from which the imported product has been manufactured or produced in whole or in part. Let's try to understand the logics. So when we talk of schedules, when we talk of tariffs, of charges for importation, we talk of the price for market entry. And the price for market entry, which is the tariff, does not include the price of doing business in a state once you cross the border. Sales taxes of any kind, or say environmental taxes to reduce consumption, which our domestic businesses pay, are prices for doing business domestically. And these taxes should apply to all products, regardless of whether they are domestically produced or imported. I could give you the example. Let's take the example of a charge imposed on a perfume that contains alcohol. So if we have a tax on alcohol, excise tax, for instance, you all saw those marks on bottles of alcohol. It's a consumption tax. You pay for the consumption of a product within the territory of a certain country. So if you pay the excise tax for alcohol, then we could make a charge that we will impose on a perfume because it contains alcohol, if all alcohol containing products in our territory are also subject to such charges. And this charge that will be imposed must take into consideration actually the value of alcohol and not the value of the perfume, so that it could be considered somehow equivalent. Getting back to the real wording of Article 2. Which are those taxes which are adjustable? Let's once again read this, because this is one of the most complex parts of this provision. So we can adjust a tax, domestic tax, in respect of the like domestic product or in respect of an article from which this product has been, from which the imported product has been manufactured or produced in whole or in part. So that can be a charge equivalent to an internal tax. The border tax adjustment could be a charge equivalent to an internal tax, either on the product itself. So, for instance, we have a charge, we have a tax, internal tax on steel, and for the use of each kilogram of steel, you need to pay a tax. Then you can adjust this tax at the border, making each kilogram of steel pay the same amount of tax. Or, if getting back to the tax, a tax with respect, in respect of an article from which the imported product has been manufactured or produced in whole or in part. If steel is just a component in the final product, but we have a domestic tax on steel, then an adjustment could be made at the border. So this seems to be the scope of adjustable taxes under this provision. In 1970, there was the famous GATT Working Party report on border tax adjustments, and we will also mention it once again when we get back to Article 3, which I just mentioned, Article 3.2, which discussed this concept of border tax adjustment and how it could apply. The Working Party concluded that there was a convergence of views of the GATT contracting parties that those taxes which are directly levied on products were eligible for adjustment. That's what we just said. So examples of such taxes could be specific excise duties, alcohol, cigarettes, for instance, sales taxes, cascade taxes, and VAT, value added tax. And then here comes the second important part. The Working Party concluded that there was also a convergence of views to the effect that certain taxes that were not directly levied on products were not eligible for tax adjustments. And we understand why, because it says, the text of Article 2 says, a tax in respect of the product or in respect of an article from which the product has been manufactured or produced. Examples of such taxes could be social security charges, payroll taxes. Yes, producing a product is always subject to taxation. And many of the taxes which could be paid in our territory can be burdensome for our domestic producers. However, not all of those taxes are adjustable. It's only those taxes which are directly levied on products which are clearly adjustable. With respect to taxes that were not directly levied on products, we face a far more difficult question, because the wording says a tax on the like with respect, in respect of the like domestic product. Make it even simpler. You may know this classification of direct and indirect taxes. And it can be helpful in a while when we talk in this context. So when we talk of indirect taxes, which are collected by one entity in the supply chain and paid to the government, but it is passed on to the consumer as part of the purchase price. So actually, consumers pay the same excise tax on a cigarette pack or on a bottle of wine. VAT, service taxes, taxes levied on inputs of production. Those are indirect taxes. And they, to the major extent, are seemingly adjustable because they are levied on a product, or at least we could establish a link, a very close link between the product and the tax. For some taxes it is easier, for some taxes it is more complicated, but indirect taxes are relatively safe given the terminology of Article 2.2a. However, with respect to direct taxes, which are paid directly by an individual or organization to the government, it is far more difficult. Income taxes, corporate taxes, wealth taxes, gift taxes, estate taxes, anything. It is far more difficult because, again, those are not taxes in respect of a product. Those are taxes in respect of an activity. Those are taxes in respect of an income, whatever. If we were to permit adjustment of all taxes, including direct taxes, we could end up in a real trade war because taxation mechanisms and systems are very different across the WTO members. And WTO members really apply different taxes. WTO members really, even for the income tax, you can take an offshore jurisdiction and compare it to some of the Western European jurisdictions, and you will see how dramatically different the burden of the income tax is. Should you start trying to level this playing field, you may end up in the totally unpredictable and totally unsystemic world and trade war. So in order to avoid that, at least there is some policy reasoning behind it. But that could be the guiding force of the text. But the text is clear, and from the legal perspective, we understand what is written here. The tax should be in respect of the like product, like domestic product, as compared to what is being imported, or in respect of an article from which the product, the imported product, has been manufactured or produced in whole or in part. So this is the concept. More or less clear, I hope so. Now let's talk of the more problematic matters which relate to this border tax adjustment, because border tax adjustments were not applied that broadly in some discriminatory or obviously illegitimate fashion, and we did not have that many disputes with respect to border tax adjustments since 1947. Those systems do exist and border tax adjustment mechanisms do exist, but usually they are more or less clear and transparent in some of the countries which apply them. There are some border tax adjustments in India, there are border tax adjustments in the United States, but again, there was not much of a problem with that. Now let's take the most recent discussion, which dates back to the beginning of March 2020. And actually, this is not that new, because this discussion and this story has been there on the agenda for many years, but now it starts taking some shape that requires already some analytical approach towards it. The European Commission announced a proposal for a directive. It is the so-called EU Green Deal, Carbon Border Adjustment Mechanisms. And it is one of the further steps in order to expand the European approaches towards the protection of climate and reduction of greenhouse gas emissions towards other nations. So what is there in the summary of the initiative? Here is the citation. The Europe's effort to go climate neutral by 2050 could be undermined by a lack of ambition by our international partners. And it is indeed the case. We know that many of the other even leading nations are not as concerned with respect to greenhouse gas emissions as the European Commission is. But again, we don't know if it is something they should be blamed of in a way that they are sovereign nations, and always best would be an attempt to reach some form of an agreement than to go for unilateral trade actions. But now let's put that aside. This would mean a risk of carbon leakage, that lack of ambition by the international partners. This occurs when companies transfer production to countries that are less strict about emissions. In such case, global emissions would not be reduced. This new mechanism would counteract this risk by putting a carbon price on imports of certain goods from outside the EU. That is the initiative. And actually, the text of the mechanism is not yet released. It's just the announcement of the proposal that is there, and the discussion still ongoing. But in order to understand the approach, we need to have a brief understanding of the European system of emission trading. So in order to reduce emissions, the European Commission has been following the so-called emissions trading system. And it is implemented for already many years, and it now covers, according to the website of the European Commission, about 45% of the EU greenhouse gas emissions. And here on the slide, you may see those three major greenhouse gases, which are covered by this emission trading system. So should you be involved in one of those production spheres covered by the emission trading system with CO2 emissions or N2O emissions, you are under an obligation. Again, it's not that straightforward and simple. I simplify it, but you are under, generally, if you are a big producer, you are under an obligation to obtain a permit to emit your CO2 or NTO or whatever. So whenever you are a big producer, in order to emit, you need to obtain a permit. And those permits are created, are distributed by the European Commission in various forms and various manners. But in order to meet the overall cap, so that the total amount of emissions would not actually exceed the amount that the European Commission has as its goal. So there is a total cap, and then within this cap, there are permits which will be distributed as amongst the industries, those who seek for those. And the emission trading system implies that some of those permits can be distributed free of charge, but for most cases, those permits are sold in a market. So they are sold at auction. And there are several auction sales that happen in the course of the year. And if you are a big businessman, you know that you need to emit CO2. You would go and buy this permit at the auction. So this emission trading system really works as a market mechanism. So there is a limited amount of emissions available because there is an overall cap. and therefore those emissions, when sold at auction, according to the basic rules of the functioning of the markets, can become really very, very expensive because there can be shortages. Some industries have the permits, and there are many industries that don't have the permits, and the more is the demand with limited supply quota, the price necessarily goes up. So we may see some of the examples. I am bringing you, for instance, the article from the Financial Times of July 2019. It says EU carbon price soars to 11 years high. So now they say that the EU carbon price now topped 28 euros, and it's a record-breaking rally, whatever. So all those mass media type of statements, but we understand the concept. This carbon price can be high, and the carbon price does really influence the price of production, because this is one of the components of the price of the final product. And because of the high price of this carbon, your domestic product can become not competitive as compared to the foreign product. Take the example of the United States. In the United States, there is no federal system of emission trading. And therefore, the steel pipe that was produced in the United States has not paid for CO2 emissions in the course of production. Whereas the steel pipe that was produced in the EU has to pay those emissions. And with the increase in carbon price, this artificial tax for environmental purposes turns out to make your domestic product not competitive. And the further you start reading about that, and if you read newspapers, you always regularly come across all these discussions on the EU carbon price. I could give you the more recent from Bloomberg Green, for instance. Carbon pollution costs are likely to rise again. And they give us the graph which specifically shows how prices were rising. And we see that the prices are relatively high. So 30 euro for a metric ton of greenhouse gas emissions. So this system has been there in place for quite a while. And there has been a big scandal when the EU decided to expand this system to commercial aviation. There were several disputes, and also a dispute that was initiated. Well, there were discussions in various international organizations, and there was a case initiated by the American Airlines before the European Court of Justice. However, most importantly, at least until 2023, foreign commercial aviation is not included in the scheme unless we talk of inter-EU flights. But here is the cartoon from China Daily, which specifically talked about this story of the EU carbon tax, which was expected to be also applicable to the foreign commercial aviation. And for some of the low costers, it was considered to be dramatic, because it was claimed that the price of a ticket may increase, for each ticket may increase because of the need to purchase those emissions, those permits. The price of a ticket may increase by $7 or $10. You know that there are low costers that just offer tickets at a cost of $7 or $10 in sometimes. As of now, until 2023, there is no plan to apply this to foreign commercial aviation, so we could put that aside. But now we understand that with respect to foreign products, there is an attempt to develop some form of an adjustment mechanism, potentially using the instruments of Article 2.2a. What is this proposal of a border tax adjustment in the EU Green Deal? The EU Green Deal should develop some carbon border adjustment mechanism, CBAM. And EC, the Commission, intends to present this proposal by the summer of 2021. They say this would ensure that the price of imports reflect more accurately their carbon content. So there is an idea that we could adjust this difference in pricing, which results from the more environment-friendly approaches in the EU, which impose an obligation on European businesses to pay for emissions. One of the most unclear matters here is how to evaluate the carbon content in a product. Because when a product arrives to your border, you don't have any accompanying documents that would give you understanding on how much was emitted. There can be certain measurements, certain yardsticks that you could try to apply so that to have the more or less correct understanding. But again, technologies can differ, climate can differ, and in some warmer climates, less CO2 emissions would be needed for, I don't know, for heating even your production facilities. Generally the technology of the same production of a steel pipe or steel itself can differ, and emissions can differ. But even if we take that aside, and even if we understand that there is some way of calculating it, and potentially that will be a self-declaration, and the importer would be identifying the amount of emissions with the right of the EU border control to make some clarification or adjustment if needed. But the other tricky problem is to understand what would be the mechanism of ensuring equivalence. You saw the graph and you saw that there are permanent fluctuations in the cost of carbon emissions within the EU. And you remember that under Article 2.2a, we need to ensure that such a charge will be equivalent to an internal tax. But this border tax adjustment doesn't work purely with a tax. It works with this charge in a form of a price for the permit. And as long as the price of a permit is determined through market mechanisms, those prices are not stable. So what is the moment in time when you understand the equivalence? Is it the day of the price, the day when the product was produced? Is it the day of importation? If so, why? If those emissions happen in several stages, which is the correct date to identify the measure of equivalence? So it is far not that simple. Here is back the text of Article 2. A charge should be equivalent to an internal tax. But how could this charge be equivalent if we say that calculating emissions abroad is difficult? It is difficult to ensure equivalence given the carbon price fluctuations. However, it is not the only problem that is triggered by this initiative. The second question we should consider when looking at Article 2.2 and bearing in mind this European initiative is whether this ETC charge is at all adjustable. Is it an adjustable tax? So when looking at the wording of Article 2.2, have a careful look at the text You can even put the video on pause for a while and try to understand why this tax or this charge would not necessarily be adjustable. Give yourself a minute to find a problem in the wording of Article 2.2, which could threaten the legality of this European initiative. So the concern here is actually whether this charge is an adjustable tax. Look at the wording. It says that the tax shall be in respect of the like domestic product or in respect of an article from which the imported product has been manufactured or produced in whole or in part. What is being taxed in the emission trading scheme? It's the emissions, right? So we pay for the emissions. Emissions are not the product that is being imported. So it is not a tax on the like domestic product. It is not greenhouse gases which are being imported, which we want to tax adjust at the border. We charge emissions. Are those greenhouse gases fitting the second part of the provision? Article from which the imported product has been manufactured or produced in whole or in part. Take an example of a steel pipe. Is a steel pipe somehow produced in whole, manufactured or produced in whole or in part with greenhouse gas emissions? Not necessarily. So greenhouse gases are not most likely reflected in the final product. There are certain theories that are being developed to talk of this carbon footprint and to support the idea of the reflection of the emitted carbon in the final product. But I am not sure if the wording of the text of Article 2.2, the exact words used, would give us this freedom of interpretation. Greenhouse gases are emitted. They are not reflected in the final product. So it is very unlikely that we could consider those greenhouse gases as articles from which a steel pipe was produced or manufactured in whole or in part. So there is a big doubt whether these are the right words to be justifying particularly this ETS border tax adjustments. So again, I'm not saying I'm against some even trade measures to combat climate change. I'm just trying to figure out the legality of the mechanism which we are now considering. I'm trying to figure out if the wordings of the provisions are maybe strict in a way that some of the instruments would not be that easily available. So we have talked of the exceptions to Article 2. We have talked of charges for services at the border and border tax adjustments. So these are the 2 out of 3 exceptions. The third exception, anti-dumping and countervailing duties, is subject to our next lecture, which we will now switch to.